Hello and welcome to Keller and Heckman's webinar, ADA Website Accessibility Lawsuits, Current Legal Landscape and Risk Mitigation Strategies. We are glad that you could join us today. We have a few administrative notes to share before beginning today's program. This is an informative presentation and not intended to provide legal advice. All lines have been muted. If you have a technical issue, please feel free to send us a message using the chat box. If you have a content-related question, please submit it in the Q&A box. If time permits, we will offer a question and answer session at the end of the program. And now I will pass the microphone to Ro, a member of the firm's litigation practice in our San Francisco office, who will begin today's program.
Hi, everybody. Thanks for being here today. Happy to present on this issue, and I hope you find it useful. We're going to talk today about ADA website accessibility lawsuits. I have had a legal disclaimer here, but I think we've already gone over that, so I won't go over that in detail. I'd like to just start off by providing a little bit of an outline of what we'll go over today. The main goal of today's discussion, from my viewpoint, is to provide you all with a broad overview of the issue of website accessibility in and of itself, and with respect to the ADA and the litigation that's ensued from that. The main goal is to provide you awareness of this issue. I think that is a very important factor for getting you on the road to looking at your websites and reducing the risk that you're going to be in the crosshairs of an ADA lawsuit or a similar lawsuit under a state disability related law. So we'll go over the general premise of what is web accessibility, go over some guidelines for making your website or your mobile application accessible. We'll talk a little bit about the Title III of the ADA as applied to web accessibility. We'll go over some of the significant case law that's out there. I think that'll give you a good idea for some of the issues. And then lastly, we'll talk about some risk mitigation strategies. Again, how to prevent your company from being in the crosshairs of a lawsuit or receiving a demand letter. So the first topic, what is web accessibility? You might be asking yourself, what is this? What is this concept? I wasn't aware of this. According to the Web Accessibility Initiative, this is part of the World Wide Web Consortium. That's a group that we'll talk a little bit about today in terms of some standards that it's issued, but it's a private group composed of industry, some universities, and others who have the goal of making the web more accessible to persons with disabilities. So their definition is making or developing websites, tools, and technologies that are designed and developed so that people with disabilities can use them. So relatively simple concept, but there's a lot of detail involved in that with making a website or making the internet fully accessible to people with disabilities. Disabilities that can access web access are listed here: auditory, cognitive, neurological, physical, speech, and visual. That last one there, the visual impairments, people with either low vision or folks that are blind, that is a significant issue in terms of who is filing lawsuits making discrimination claims under the ADA. Those are the primary folks and their attorneys who are doing that. So we'll focus in on that particular disability. Relevant to that disability is the issue of screen reader software. Some of you may have be familiar with that concept, others may not be. But in general, what it does is it vocalizes both the visible text that we can all see on a website, and it essentially reads it out which allows someone who's visually impaired to know what's on the website. It does that with the visible text, but also with invisible code, sometimes called alternative text or alt text. And this is text that's embedded in the website beneath something like an image or a graphic that will provide a textual description of what that is. That is the way that that can be communicated to someone who is blind or otherwise visually impaired. So this is a significant issue. I put in another stat here on this slide. As of 2012, the Census Bureau report indicated that 57 million people in the US had disabilities. I think of that, the statistic was there was around 30 to 35 million who were characterized as having pretty significant disabilities. So it's a pretty large part of the population in general. So before we get into all of the websites and the lawsuits and the demand letters, and some of the costs of making your website accessible, let's talk about some of the benefits. Some of the benefits, as noted in the literature, can be increasing the number of possible visitors, users, or customers to a website or an app. May also help mobile users, older users, people with slow connections, access your site. And also importantly, I don't, it's not something that I thought about a lot, but there is an indication that optimizing your site for the disabled also may help you in terms of allowing a search engine to index your particular site. That can have some benefits for your business as well. This could lead to some financial benefits, more sales, services provided, ad views, and content consumed. And then lastly, what is the benefit of making a website accessible? Well, there's the reduction in the risk of Title III, ADA, or other state equivalent lawsuits. Statistics here, 2019, there were 11,053 ADA suits filed under Title III in the federal courts. That went down a little bit in 2020. That may have been related to the pandemic, but it's still a pretty significant number. Important to note are that these statistics are only for federal lawsuits, which it's a little bit easier to get the statistics on those. State courts are a little bit more difficult in terms of compiling that information, but these numbers don't include state lawsuits, and they certainly don't include the hundreds and hundreds and maybe even thousands of demand letters that have gone out that have resulted sometimes in settlements without any case being filed. What are some of the the obstacles to full accessibility of a website? You might think, well, I might just go, I'll just go ahead and I don't want a lawsuit, I don't want a demand letter, I'll just go ahead and make my website accessible. So one of the issues with that, of course, is cost. For a larger website that might have hundreds or even thousands of different pages, the cost can be somewhat significant. Another issue is that websites, of course, are dynamic things. They are not like a physical location that has certain architectural components that don't change. Websites are and apps are updated often, sometimes daily, sometimes hourly, maybe even more than that. There's an issue with that's been the subject of litigation that some businesses feel that due to the cost of making a website fully accessible, that alternative means of access may be more efficient. The primary one being, if someone can't access the information on a website, an alternative could be to provide a customer service number so that someone can access the services of your website. That's been the subject of litigation, and courts have sometimes found that alternative means of providing the services of the website is problematic because there's less privacy involved with actually picking up the phone and calling a business. And sometimes, as you all know, calling up a customer service representative sometimes is not an efficient means of getting what you want. And also there's some phone numbers that have been provided where you can't access them. You can't access a rep 24/7, whereas a website, generally you can go on and order a service or product anytime you want to. There's also an issue involving third-party content. If a third party is posting content on your website, who's going to be responsible for ensuring that that material is accessible? So that's another issue as well. So you might be saying to yourself, well, how do I make my company's website accessible? And that is a question for a web developer. However, we talked a little bit about the W3C. This is an entity that has issued some content accessibility guidelines called the WCAG. This is really the standard that's out there in terms of if you conform to these guidelines, can you feel potentially that your website is in or accessible to folks with disabilities. These have been developed with the goal of providing a single shared standard for web content that meets the needs of disabled individuals, businesses, and governments. There's 3 different levels under these guidelines, AAA and AAA. AAA is supposed to be the most accessible, the most in terms of addressing the most disabilities and making a website or an app the most accessible. The WCAG has a couple different versions that are out there. The current one is the 2.1 WCAG, but there's also a 2.0. Level A and level AA, which includes some success criteria, have been adopted under Section 508 of the Rehabilitation Act. That applies to communication technologies of federal agencies. So federal agency websites need to comply with this WCAG 2.0. So it is a pretty significant standard. It's been discussed by the courts. Obviously, it's been adopted by legislation, and it really is kind of the standard that's out there at this point. So just taking a look at the WCAG, and this is the 2.1. It's organized into 4 different general principles in terms of accessibility. Those are perceivable, operable, understandable, and robust. Under each of those principles, you'll find that there are specific guidelines, and I've got those listed here. And there are 13 total guidelines under the 4 principles. I'll go to the last 2 principles, understandable and robust. So each of the diamonds here is a particular guideline. And under each of those guidelines are some actual testable success criterion that you can measure your website to in order to determine conformance with the 2.1 standards. And those are leveled at the A, AA, and AAA. For the WCAG 2.1, there are 78 separate success criteria. So if you want to comply fully with the 2.1, you've got these principles, you've got these guidelines, and then within those, you've got a lot of success criteria. The number of criteria that are out there and how you get to conformance with these standards is what potentially makes that a relatively expensive undertaking. I've seen some cost estimates on this that have been disclosed in the litigation, and some of those can be pretty significant for larger sites. There was a defendant in a significant case that we'll talk about who estimated the cost would be about $250,000. So this is not, in terms of full conformance with these standards, a insignificant undertaking. So I wanted to provide here an example of one of the guidelines. Hopefully you can see this okay. See that it looks like it's a little bit small here on my screen. But this is guideline 1.1, which discusses text alternatives. The success criteria is listed, and then under that are various points that need to be analyzed by someone who's going through this and looking at the conformance of your website with respect to these standards. Now, these standards are voluntary standards at this point. They have not been adopted with respect to the private sector, but courts are looking to them, plaintiffs' attorneys are looking to them, and the Department of Justice also is looking at them and making them part of their settlements as well in ADA cases. This is a really good resource. There's a lot of information here on the W3C's website, and under their listing of the guidelines, everything's publicly available. There's a lot of information on what each guideline means. I highly recommend, especially if you are in the process of conforming your website, or even if you've already been hit with a demand letter, to look at this criteria to see if the plaintiff's allegations are meritorious. You can get a lot of information here on their claims. Okay, so moving on, I'll provide a little bit of background about the ADA as applies to private entities, and that's Title III of the ADA. And this is where a significant amount of the lawsuits involving website accessibility have been filed. Just a little general background, this is a 1990 civil rights law that was amended in 2008. Discrimination is forbidden against disabled individuals in employment, public services, and with respect to private entities that are public accommodations. Title III of the ADA is what's applicable. Title III in general indicates that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations, and this is important here, of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. That's been a significant part of the litigation. The DOJ is responsible for issuing regulations on the ADA, Title II and Title III, and also has enforcement authorization as well. But most of the time, what you're going to see as a business with web accessibility or other types of ADA claims is private enforcement. Under the ADA, injunctive relief is available, as well as attorney's fees, prevailing party attorney's fees, and that is the significant driver, as you can imagine, for these cases. Damages are not available under the ADA. However, damages are available under some equivalent state laws, such as California's Unruh Civil Rights Act. Plaintiffs in those cases can get damages of up to $4,000 per violation. Specific forms of discrimination. So there are various forms of discrimination. Some of them you may be more familiar with, like physical barriers to a retail location. I think there's a lot more familiarity with that issue. Physical barriers can include, something like a lack of wheelchair accessible ramps to the front of a retail store, a lack of disabled parking spaces, paths of travel within a retail location that aren't wide enough for maneuvering of a wheelchair, sales counters that are too high, and the list goes on and on and on. We're not talking about that kind of issue here with respect to web accessibility. What we are talking about is the alleged lack of auxiliary aids and services that may be necessary to ensure that there's no discrimination occurring. Under the DOJ regulations, public accommodations must furnish appropriate auxiliary aids and services necessary to ensure effective communication with disabled individuals. So in terms of the web accessibility issue, we did talk about screen readers, and screen readers need to, under this auxiliary aids and services provision, be able to pick up the information on your website. So an auxiliary aid or service as defined under the case law that construes these provisions is technology that can make your website readable by a screen reader. So that's how this issue kind of gets captured under the ADA. Again, another kind of distinction between the issue of physical barriers to accessibility and the website issue is the lack of standards for adopted standards for websites. For architectural barriers, the DOJ has issued these very technical and detailed standards for compliance. Those were issued in 1991. Updated standards were issued in 2010. Examples are, some of the things we just talked about: parking spaces, height requirements, width requirements for path of travel. Those are all out there. They are very detailed. They go to the number of inches. If your counter is 37 inches and it's supposed to be 36 under the standards, you have a violation. We don't have anything similar like that for websites. Even though the DOJ has taken the position since the mid-90s that websites are covered under the ADA, no standards have been adopted. The DOJ has issued rulemaking previously, but withdrew that in 2017. But the DOJ in some of its larger settlements has required companies to comply with those WCAG 2.0, and I've seen some recent ones under 2.1 as well. Some of the justifications that the DOJ has for that is that the lack of specific standards allows businesses to comply with the ADA in many different ways. So it allows more flexibility. Industry businesses, on the other hand, have been complaining for really many years that the lack of standards makes it very, very difficult to determine how to comply with the ADA in terms of websites. So that's an ongoing issue and a frustration of many businesses. So I highlighted a little bit earlier when going over the Title III statute, the issue of public accommodations. That's a significant question in terms of websites. Public accommodations are listed under the statute and the DOJ regulations. There's many examples of those. It's been called an expansive list that covers most physical locations in which individuals are going to find themselves in their daily lives. Neither the statute nor the DOJ regulations includes any identification of websites, mobile applications as public accommodations. So what are these public accommodations that have been listed under the statute and the regulations? So I've got them here. You can see these are all physical locations, and the case law, most courts are looking at these and saying, look, these are all physical locations. Websites are just simply not included. But one thing I think that you're going to want to be aware of is, and to ask yourself when looking at this website accessibility issue is does your business fit within one of these categories, these broad categories? Do you have a physical location that would fit within one of these categories? And if so, then do you have a website that is available to the public? If so, this is an issue. The ADA and accessibility is something that you're going to really want to think about. I'll go over some of the significant case law. First, our websites and moving on here, our websites and acts subject to the ADA. That answer is going to depend on the jurisdiction and the type of business. Two categories here: websites of online-only businesses. Courts have gone in both directions. Websites of businesses that have physical locations where goods and services are offered. Primarily, courts are finding that those websites are subject to the ADA. Some courts have gone in the opposite direction. One of the most significant cases is the Robles versus Domino's Pizza case. There's an allegation by Mr. Robles that he couldn't access the website because the screen reader couldn't read those websites. He filed suit in 2016 under the ADA and the Unreached Civil Rights Act. Domino's primary argument, or one of their arguments, was that the ADA does not cover their online offerings. District Court held that the ADA applies, but dismissed on due process grounds relating to the DOJ's failure to issue standards on website compliance. That case went up to the Ninth Circuit, and the Ninth Circuit reversed on the auxiliary aids and services issues. The important statement here that the court recognized in its opinion is that the services of a place of public accommodation, not services in a place of public accommodation, are subject to the ADA. So you don't have to be within a physical location for the ADA to apply, as long as the service being provided is of a public accommodation. So the court found that in this particular case that the website and the mobile app was subject to the ADA. The court holding was that going back here, the alleged inaccessibility of the website impeded access to the goods and services of Domino's physical locations, which are clearly places of public accommodation. That was true even though there was other ways to order, but the online means was the primary means and was also heavily advertised. So the case went back to the district court after Domino's petition to the U.S. Supreme Court, pointing out that there is a circuit split on this issue of the applicability of the ADA to websites. Case was Supreme Court denied review. Parties filed motions for summary judgment. Essentially, Domino's lost. It was required to conform its website to the WCAG 2. Important part of this holding, I think, and a little nugget here for settlement negotiations, if you get a demand letter, especially under the California UNRU Act, is that the court here in its order found that statutory damages would be limited to $4,000. Whereas in other cases, you could get $4,000 per violation. The court said that every time that the plaintiff went to the website, they encountered the same barrier, which was the inaccessible website, therefore the same violation. So when you're looking at these demand letters and the plaintiff's attorney says, well, hey, my client went to the website 10 times, that's $40,000. This is a good case to cite in trying to limit that to $4,000. Moving on here, because I know I'm running out of time. The Winn-Dixie case is another important one from earlier this year. The court kind of went the other way. There was an allegation, again, a screen reader software issue that it couldn't read Winn-Dixie's website. The plaintiff there wanted to order prescriptions for pickup and download coupons for use at Winn-Dixie stores. District Court found that Winn-Dixie violated the ADA. 11th Circuit reversed, saying that websites in and of themselves are not public accommodations. And it also went beyond that and said, well, even if the ADA still regulates websites, in this particular case, Winn-Dixie's website didn't pose an intangible barrier to access to the goods, services, and privileges of its stores, essentially because the website was a limited use website. It could be used to initiate certain actions such as ordering a prescription, but you still had to go into the store in order to pick up that prescription or use those coupons. So the court said there really was no barrier here to access because you still had to go to the store. You could still get the services provided, even if you couldn't access the website. Another one here that I will just leave for folks to look at later is a California case, the Thurston case. This is a standing case under the Unruh Act, and I'm going to skip through that one because we need to get to risk mitigation. In terms of risk mitigation, I think the first thing here, as I said earlier, the most important aspect for a business, I think, is to be aware of the issue that the ADA can potentially apply to their website. We still get calls where, clients will say, I didn't even know this was an issue. Why would my website be subject to the ADA? And at that point, they're already faced with a lawsuit or a demand letter. So if you can get out ahead of this in terms of awareness, I think that's a good idea, and you can take some action. One of the quick things you can do to look at your particular website is to use a evaluation tool. I've listed one here. This is a great tool. It's by Utah State University. If you go onto their website, I've listed the URL here. You can type in your company's website. What you will get is a report. This is the USDA's website. On the left here, you can see some listing of errors, contrast errors, and some alerts. This website will compare your website to the WCAG standards and provide some information on where your errors might be. If you look at the USDA website, there are some errors here listed for missing alternative text. So some of these graphics here are, coming up on this text as not having the appropriate alternative text. So that's a good place to start, just to get an idea of what the issues might be. Something you can do as kind of a quick fix on your website is to use something called an accessibility overlay. This is essentially something that does a couple things. It'll allow a person with a disability to adjust the website user's interface to their personal needs. Got an example of that here in the slide. This is a overlay called Accessibility. It's a pretty well-known one. It provides a way for the user to adjust some of the content on the site. This one will also run an AI-based application in the background that will optimize the accessibility of the website. It adapts to screen readers and makes the website compatible with keyboard functions. This is something you can employ really quickly. It's relatively cheap, but it doesn't change the underlying code, the underlying source code. It's not necessarily going to make your website conform completely to the WCAG 2.0 or 2.1. There's been some criticism of these types of overlays. They don't do everything that you need to do in terms of conformance. And also, there is some indication that they may slow down the performance of your website. That's something that some businesses want to avoid because of what that effect that might have on search engine rankings. They also include an accessibility statement, which will tell someone who's having trouble with the site to contact your business if they are having those issues. Another thing is putting one of these on your site. It could have the effect of discouraging a plaintiff's attorney. So this is something that is worth serious consideration. The other risk mitigation strategy, of course, is manual conformance with the WCAG guidelines. There's significant costs in that. One of the things that you can do quickly is to ensure that you're uploading readable PDFs to your website, provide closed captioning and embedded transcripts for videos and podcasts. And there's always the option here, something that we've advised is to start with an overlay. It's cheaper. It can be put up in 24 hours, and then take the time to work towards manual conformance. If you do get a demand letter, I think some questions to ask are, does the website owner, you as the business, have a physical location that is a public accommodation? Are there, the Winn-Dixie case supports this, are there alternative means provided for accessing the services of the business? That would be important under the Winn-Dixie case. Under the Robles case, you might not get that much mileage out of it. If you get a demand letter, really make sure that the assertions made in that letter are accurate. There's hundreds and thousands of these letters going out, lots of mistakes in them. So you really need to look at the alleged violations and see if you've got arguments that they're incorrect. And then also, I think look at, can these violations be fixed quickly? An overlay is one way to do that. So that's something that should be considered as well. That is near the end of my presentation here. I'll take the opportunity here to answer any questions that are out there. So one question that we have is, which way is the case law trending in terms of website accessibility? I would say in that respect, we really need to be thinking about as businesses and as attorneys representing them that the case law is trending towards the ADA applying. The one arena where that may not be true is web-only businesses, online-only businesses, but with respect to if you have a physical location, that's going to be something that is going to rope your website in under the ADA. So I think we've gone over the time limit here a little bit. If you still have questions, feel free to reach out. My email is right here. Thanks for attending, and I hope that was helpful.